What do the judges need to know about the writing of the impeachment clause in order to understand its meaning?
Well, I think one thing that's important for them to know is to realize that, in a certain sense, the framers struggled with the clause. But in the end, they came. There's a kind of curiosity in the way in which it was framed. That over the course of its debates, the framers of the Constitution narrowed the language of impeachment to two specific charges: treason and bribery. And then, when the delegates actively discussed it towards the very end of their deliberations, George Mason said, "Well, those charges are too narrow. We actually need to broaden the potential scope of mischief for which presidents could be held liable." So he said, "Why don't we add maladministration?" And James Madison thought that would be a terrible mistake. Madison and Mason were colleagues in the Virginia delegation. Madison felt maladministration was an open-ended term. If you want to protect the constitutional independence of the president, you needed to be more specific. So in a fairly quick exchange, and one that really wasn't seriously debated, Mason reached back into English history and summed up the famous words, high crimes and misdemeanors, which is a very nebulous phrase, which has led to, I think, a lot of confusion and uncertainty in the contemporary American political vocabulary. But I think the key thing to know is the framers to some extent wanted to limit the power. They wanted to protect the constitutional independence of the president, but at the same time, they wanted him to be responsible for his conduct in office. And I think responsibility was really their dominant concern.
As you read the clause, do you believe that Donald Trump can be prosecuted for some of the same things that he was acquitted of in the Senate trial?
Of course, because these are two very different, radically different procedures. An impeachment procedure is essentially a political judgment. It deals with the question, is the individual in question, is he competent or not to be the sole holder of the executive power of the United States, which is what Article 2, Section 1 says. The executive power shall be vested in a president of the United States. So if you've reached the point where you say he's incompetent to hold that office, whether it's because he's committed bribery or treason, or certainly has supported insurrection, which was designed to prevent the lawful completion of an election, that's essentially a political judgment. At that point, it may well be the case that he has committed identifiable crimes that are worthy of prosecution, that he should indeed be vulnerable to conviction and to punishment. At that point, a whole different set of protections should click into play. I mean, everything we think about is due process of law. The right to have counsel, the right to summon witnesses, the right to be subject to all the usual proceedings that we see as the essential safeguards, in many ways protected by the Bill of Rights. But the key thing is these are two very different procedures. One is designed to reach a political judgment, and the other is to deal with its legal consequences. The one that should matter most to us as citizens is not whether or not Trump spends the rest of his life in jail. It's whether or not he should either be allowed to should remain in office or should be prohibited from running for office again.
We have never appointed an historian to the United States Supreme Court. Nothing prevents us from doing it. They don't have to be lawyers. It has turned out that way that they are. But when you watch the Supreme Court justices and their clerks, in effect, playing the role of amateur historian, staring at these words, believing that if they stare long enough, they can know what was in the mind of the people who wrote them. What is your reaction as a historian?
Well, since Andrew Weissman was talking earlier about the whole Second Amendment issue, basically it's turned into a real mess. And there's a lot of discussion going on among historians, among lawyers who read history, among jurists, particularly in the aftermath of the famous Second Amendment decision in the Bruen case from a year and a half ago. The court says, on the one hand, it wants jurisprudence to be deferential to and respectful of history and tradition as well as text. On the other hand, its method for dealing with history, most historians like myself would argue, has been very inadequate and very flawed, and in some ways really irresponsible. And in some ways, the Second Amendment, because it's been so much litigated, is the best example of this. I mean, the fiction, the theory underlying the original DC versus Heller case from 2008, that the Second Amendment was really about a personal right of self-defense. To a historian like myself, that's complete and utter nonsense. Nobody in the 18th century thought when the Second Amendment was being debated, that they were discussing personal rights self-defense. It was all about the militia. And, you know, since I was the lead author of the historian's brief, D.C. versus Heller, I have very strong feelings on this subject. But the court has kind of laid down this challenge, and now it's trying to make sense of how to deal with it. And, you know, judges around the country are actually begging for help because they realize there's a limit to their historical intelligence. And the whole question of how should judges at every level of jurisprudence, how should they be better informed historically, become a real challenge, a real problem. And I don't think we've figured out quite yet what the solution is.
Well, one possibility is don't take all of your clerks from law school. Have at least one of them be a historian, because Supreme Court's justices can have 3 or 4 clerks if they want them. They could easily have one be a historian.
Right. Well, look, I've had about 7 or 8 of my Stanford students, I'm proud to say, have clerked on the Supreme Court. I'm in Stanford history majors, so I think that's a nice fact. Whether it's adequate, you know, given the way the appointments process works, is another question. You know, one way to think about this is maybe historians, maybe one should think about history as a form of expertise, and the courts, the Federal Judicial Center, should think about ways of constituting panels of historians. I'm involved with a group of historians and legal types at NYU, at the Brennan Center at New York University Law School, and we're actively working on this problem. In fact, we're about to make an announcement of our very existence. So I think there's a real challenge out there as to how to make the court, or courts in general, be better informed about how to work with historical materials. You know, there's a lot of criticism of what we call law office history, which takes the form of find me a site which will sustain the argument, the conclusion I want to reach. There has to be a better way to do it. It's more responsive to the historical records and really more accountable to the body politic.
Professor Jack Rakoff, an honor to have you join us for the first time tonight. I hope you can return as the Supreme Court wrestles with these issues. Really appreciate it.
Oh, it's been a great pleasure to be here. Thank you so much.
Thank you.